I just had a case recently. Young woman passed away, but dad had 50-50 custody. So then it was a bit of a fight because grandparents wanted their visitation, and in family court, grandparents can bring an action for grandparents' rights. But in your experience, does that now go to the probate court, or will they kick it back to family court?
It's up to the judge. So if there is already, what I usually see is if there is already a pre-existing case, then family court retains jurisdiction. But where there hasn't been, let's say, a divorce proceeding, a custody battle, but there's been a death in the family, then usually, so there's this pre-existing order, but there's nothing pending, no impending proceeding, then that's where you do come into the probate court and you seek a guardianship order, whether it's guardianship over this. Now we're talking about guardianship over the person. And so that's where you seek an order of visitation of some sort, depending on what happened in the family law court, because if there's been some kind of, not the 50-50, but if there's been some sort of determination that they're an unfit parent, then there would need to be some kind of guardianship action that takes place.
How does the probate court view grandparents? Is there's a high? I know parents have rights, but after that, are grandparents favored? Are siblings favored? Kind of what is the hierarchy
in terms of who gets appointed as the guardian? Or the hierarchy is parents, then siblings, but it is absolutely to the court's discretion. It depends on generally the relationship, the time spent, the nature of, because even if it's a grandparent, but the child never met this grandparent, but they've been in the quote unquote custody of, let's say, a sibling or a niece or nephew, then that person, the court's going to give them more weight depending on their relationship with the child.
There's a lot more gray area.
So much.
than I actually anticipated. But I think we kind of touched on this, but in the preparation of a trust, can't it cover a lot of these issues that we're talking about?
So the trust is going to absolutely cover, especially when it comes to guardianships and children, because in the trust, now you don't have to come into court if there is a trust that's been established to have a guardian of the estate appointed, because as we discussed, now you have already made a determination. And the same is true just with respect to if you don't have a trust, if you have estate planning documents where you've made a nomination for who should serve as the guardian, then that too is extremely, extremely helpful. I would just say it's essential to have that appointed, because otherwise now you have people battling it out in court, and ultimately those fees and costs are going to chip away at what you intend the child, or what you would desire the child to ultimately inherit. So definitely when it comes to the children, you definitely want to have an estate plan.
You brought up an important issue. How much would something like that cost if people are fighting, and that comes out of the estate, right?
It can ultimately come out of the estate. So usually in the beginning, you're having to advance your own funds. But in the event or upon appointment, then you can petition the court to have the guardianship pay those costs, because ultimately it is necessary and in the best interest of the child for there to be a guardian. And if you had to duke it out about who's going to be that guardian, then the court can certainly order the guardianship, depending on the nature of that guardianship as well, to pay those costs. So those costs can be, it could just be in the thousands of dollars. Because at the point where you have a contested matter, as it is with just all matters, you're in the upwards of tens of thousands of dollars as soon as a matter is contested and you're in and out of court, and filings upon filings, then services are rendered and costs to file and various other costs are being incurred. So it's an extremely costly proceeding that isn't necessary if you have an estate plan most often.
This sounds like the conversation I often have about prenup, right? Because prenups aren't to discuss the end of your marriage or the end of your relationship or say you don't trust one another. It's a way to understand the business of the relationship. And I think a trust is very similar to that. And I just realized that today, to address a lot of these issues. So when do you recommend that someone comes to see you if they have a joint trust with their spouse? Do they have to dissolve that trust if they want to start a new trust? How does that work?
So if they're going to go through the divorce proceeding, and so I have to understand more about the stay. I hope we haven't. So we need to talk more. But so back to there being this stay, but I would venture to say that as long as the two of them are in agreement on how things should be disposed, I would think that they can agree beyond that stay.
It would have to be in writing because they're not supposed to touch the trust property or whatever's in the trust. But at some point, I suspect they need to dissolve a joint trust if they want to do their individual trust. How does that work?
Well, it would be perfectly fine after the stay is no longer in place. So if that stay has now been lifted or the divorce is now finalized, and depending on what the divorce judgment specifies and confirms as to who gets what assets, then you just automatically create your own plans. You would create your own plans.
Do you have to dissolve the joint trust, or can you just create another one that supersedes that joint trust?
So my understanding is that a dissolution judgment is going to automatically revoke the designations in a pre-existing trust. So if it's automatically revoked, then to answer your question, it's sort of an automatic, but you're going to still you're going to reinforce that in your new agreement. So that joint trust, by operation of law, I would say, as to that former spouse, those terms as to that former spouse are now revoked. And so you would just need to do an entirely new plan that says I revoke all former pre-existing documents, and I'm going to do this new plan.
So I'm assuming that you're assuming that all of the trust property is divided in the dissolution.
Yes, that's usually the case. I know that I've heard before that things could be left out, but and as for those things that are left out, then in the trust there's normally a residuary clause that ultimately, depending on if it's separate or community property, then that can be designated to certain beneficiaries as well. So you would need to do that in the trust. I hope that answers your...
It does. And it is so much crossover. I think it is very, very important while you're going through a divorce to also talk to a trust attorney so you know what that turnover process is like, especially if there is any concerns from you or the other spouse potentially being incapacitated. Definitely should talk to a trust attorney. I think we talked about a lot of this already, but what tips would you give to people to avoid a lot of what we're talking about?
Well, you said it. Everything is about pre-planning. And so I'm sure you could speak to the prenuptial, and I can speak to the estate planning. You want to establish who your agents are in the event of your incapacity, your health care. You certainly don't want the person that you're seeking to separate or divorce to make decisions for you.
Right.
And so you definitely want to establish these plans. It's going to alleviate a lot of heartache and finances and delay with respect to people having to go through extra unnecessary steps to get things in line in order that you could have done previously.
And when we say trust, we're talking about your healthcare directives. We're talking about power of attorney. We're talking about access to your bank accounts, because I've seen a lot of people have issues with getting access to bank accounts because there's no directive anywhere letting the bank know how that happens. So this all goes back to what I always say. A lot of this is about planning. Some of it might never happen, but at least you can sleep well at night knowing that if it does happen, your kids are taken care of, your ex doesn't get all your property, and your family's not in one of our offices.
But like I say, you don't want us, the attorneys, to become your heirs.
Right.
That's what ultimately happens.
And that is what happens. Because people, can, like you said, can spend thousands and thousands of dollars between the family court and the probate court, and then there's no estate. And it all could have been avoided with a trust and a prenup.
That's right. Absolutely.
So as we conclude, we are concluding because I can talk to Tatiana all day long. But
more often.
I want to say thank you so much for taking your time to come and sit with me. And for all of you listening, thank you so much. I hope you learned a lot. I know I did. And until next time, I am Demetria Graves.